So without further ado, I'd like to introduce today's speakers, Henry Shine and Neal Pollock. Henry is a European and chartered UK patent attorney who joined Wilson Gunn in 2019, shortly after finishing his PhD in biological physics at the University of Manchester. Neal is also a qualified patent attorney and completed his PhD in chemistry at the University of Sheffield before entering the patent profession in 2008. He initially worked in-house for Taft Steel in the Netherlands and joined Wilson Gunn in 2014. Their talk today will help you better understand and navigate the path to research commercialization through a description of real-world case studies to show how the theory was put into practice for previous material science innovations. Over to you, Henry and Neal.
Thanks, George. I'll just share my screen now. Is that coming through now?
Not yet, no. Not getting anything.
Oh, right, yeah. I have to press share. Is that better?
Great, yeah, that's it.
Yeah, cool. Right, yeah, so thanks, George, for the introduction. Yeah, so I'm going to take the first half of this talk, and then Neal will introduce the final section. So just to briefly run over what we're going to talk about, we'll first have a look at kind of what intellectual property is, and I'll then run through kind of a few of the main intellectual property rights that you might want to consider in terms of research commercialization, so trademarks, designs, copyright, and patents. And we'll take a bit of a more detailed look at patents because these are often more relevant for kind of a research setting. And then Neal's going to take probably the more interesting half with some case studies on real world applications of kind of inventions that have been patented. So yeah, let's crack on with what is intellectual property. So intellectual property itself is a result of creativity and innovation. So as a researcher working in the Royce, kind of almost everything you do is going to generate intellectual property, whether that's kind of know-how, experience in your head, or the writing you're doing, poster presentations, and kind of new ways of doing things or new devices and materials that you're developing. So quite often these kind of things are intangible assets because they might just be held in your head or it's something you've said to somebody. And so you can kind of crystallize these into something that's more useful commercially using intellectual property rights. And these enable you to kind of protect an income that you might be generating as a result of that new material or process, and then can be used as bargaining chips and negotiating tools in business. So for example, you might use a patent to unlock new investment in your business, or you might use it to set up a licensing agreement with another party so that you can both benefit from each other's technological developments. And this, of course, then provides kind of a competitive advantage to your business because you might be the only person who can utilize a material in a certain way or take advantage of a certain technical process, for example. So as I mentioned before, kind of the main four ones that you're going to deal with are trademarks, design rights, copyrights, and patents. And I'll briefly touch on trade secrets as well, because these can also be useful. So with a trademark, what you're protecting is kind of the brand identity of a product or service. So this is the brand name that your customers see when they come to you to purchase something effectively. So it could be kind of Coca-Cola, Cadbury's, or kind of if you're doing a research commercialization business, then this would be something more specific to your kind of business. But it's what people identify with your business, and kind of all the kind of goodwill and trust in the business can be associated with this name. So ideally with a trademark, you do register it because this provides a much clearer kind of marker that you own that trademark, and gives you a much more breadth and kind of ease of enforcement against other third parties. Because it's just protecting the brand identity, trademark protection can effectively last forever, so long as you're using the trademark for the products or services that it's registered for, and as long as you renew it every 10 years. So this is how kind of the big names that you know of kind of seem to go on forever, and the protection never runs out. A couple of things to mention about the trademarks is that you should check the register that your brand name that you want to use is actually available. So you might have heard of Sugo Pasta and Ancoats. They were forced to rebrand to Sud Pasta because of a Glaswegian Sugo pasta that registered the trademark before them. So if you don't do searching, you're kind of putting yourself at a risk that a few months or years down the line, someone could kind of whip your brand out from underneath you if you haven't registered it and made sure that it's available. And then finally, with trademarks, they must be distinctive of the goods and services that you're offering. So for example, you couldn't have a pasta brand that was just called pasta, because then the word pasta isn't available for other people to describe pasta with. So yeah, that's just another thing to think about. So design rights. Design rights are more specific to products themselves, and they allow you to protect the appearance of the whole or part of a product. So by this, they really just protect how it looks and not how it functions. And in the UK, there is unregistered design right, but ideally you would register your design, because this means that you have a kind of a monopoly on that appearance, and it means that you can stop somebody else from bringing a product to market that looks the same, even if they've independently developed it. So some examples on the right here, we've got kind of a Dyson brush head for a hairdryer, and then a graphical design, which is kind of an icon, I guess, that you might use to control the hairdryer with. These two designs would stop anybody from essentially bringing to market like a product that used this graphical device, or like a hairdryer head that looked the same as that. It didn't really matter if these holes could be kind of filled in on the inside, as long as it looked the same, it would still infringe the design, even if it didn't work in exactly the same way. So the protection lasts up to 25 years if you've registered it, and you renew it every 5 years. And kind of the main important points with design protection are that the protection is only defined by what images you submit. So you really have to be careful that the images you're submitting are good quality and don't have kind of features in them that you could be optional or that you might not want in a few years' time. So it's really important that you speak to kind of ideally, a professional in the IP industry, because they'll be able to make sure the images you're submitting are going to kind of achieve the commercial goals that you want them to, and are going to be aligned with your business goals. And then finally, the designs in the images must be new. So you should you should file the design application before you bring a product to market or disclose it non-confidentially. So we'll just quickly touch on copyright. So copyright is protecting literary and artistic expressions. So what this means is that it's protecting how you actually put something into words or create an image. It doesn't protect the idea behind the words or the image in the same way as like a patent would, for example. So the computer code we have at the bottom right there's copyright in the words and how they're written in that code, but the actual function of the program isn't protected by the copyright at all. So that's something which you could possibly protect with a patent instead. So it's very useful because you don't have to register it and it lasts a long time, but it's also quite limited in the sense that you have to show that someone's copied what you've done, and also, like I mentioned, kind of the idea behind what you've written isn't protected. But copyright will be subsisting in almost everything which you're writing down. So, I mean, emails, posters, presentations, published articles, and also you can get kind of 3D artistic copyright in like statues, buildings even, as long as they're original works. Okay, and now we'll move on to patents, where we're going to a bit of a deeper dive. So patents give the owner an exclusive right to prevent another person from making, using, and selling a patented invention. So generally, this will be making a device or some kind of material, for example, using it. So that could be using the material to kind of build a certain product, or in a certain industry, and then selling it as well. So you can't sell a patented product without the permission of the patent owner. It doesn't give you the right to actually do anything, and the main reason for this is because somebody else might have a patent for kind of part of your invention, and so if you gave you the right to just do your invention, then their patent would kind of be worthless at that point because they couldn't stop you anymore. So the patent system works by being able to stop other people from doing what you've patented, and in this way you kind of end up with overlapping protection from different parties potentially. So for example, in a mobile phone these days there might be hundreds of different patents that protect that phone, but the kind of Samsung or Apple have come together to make an agreement where they can make the phone and everyone's agreed about how it's sorted out. In terms of what patents actually protect, it's technical inventions. So a new material, for example, could be patented, how things work in a technical sense. So a more efficient device. So for example, I've recently did something for a coating thickness measurement device to measure the coating thicknesses on like metal kind of containers or tanks. And so the device that you actually use to measure the coating thickness could be patented, how things are made, and then processes. So for example, going back to that example, how you actually make a measurement could be patented if it's kind of a new and interesting way of doing it. So patents are national rights, and that means that you need to have a patent in every country in which you want protection. So for example, if you want protection in the UK, you need to get a UK patent, and each national office has slightly different requirements for when they'll grant one. The requirements which are generally kind of similar over all of them, it needs to be new, so it can't have been publicly disclosed before you filed the application. And then as well, it needs to be inventive, which just really means it's not an obvious combination of what's been previously disclosed. It also needs to be industrially applicable, which usually isn't a problem, especially if you're kind of from a research commercialization, because hopefully what you're doing is already fairly industrially applicable. And then it also can't be excluded. So there's kind of a statutory list of exclusions that apply. For example, ones which might be relevant to research environment are kind of scientific theories and discoveries, which are just the kind of empirical scientific discoveries, aren't themselves patentable. The whole patent system is built around kind of applied science in a way. So you couldn't just patent Maxwell's equations, for example. You'd need to have some kind of real world application that gave you kind of an advantage or new technical effect. So I'm just going to quickly run through the patent process from first having the idea to grant. So once you've kind of made your invention in the research setting, before you can file the application, you need to draft a patent application, and that's kind of where me and Neil or someone similar to us would come in. We would have a few discussions with you to fully understand the invention, like why you did it and what its benefits are. And then we need to kind of distill all of that information down to effectively the clever bit, which makes it new and inventive over something else. And we kind of have to write it effectively in one short sentence that describes exactly why it's great and why it should be patented and what sets it apart from what's known already. We then also need to fully describe the invention so that somebody of kind of a basic skill level in your field could implement it on the basis of the patent document. And finally, we need to make sure that all the features that you could ever envisage kind of using or have planned to use are included in the patent document, because once we put it on file, you can't then add anything new to it. So you kind of have to try and preempt all the different features that you might want and make sure they're included. Once you've then approved the patent specification, we would file it on your behalf of the Patent Office. And kind of the main thing to remember here is you mustn't disclose it before filing. So I mean, even if you're telling somebody about it in a setting where they might then go and post about it on LinkedIn, for example, you really need to be careful and probably just avoid telling them in the first place. But I mean, if you're in research meetings and you're planning on patenting something, it's probably a good idea to tell everybody at the meeting that they shouldn't be disclosing this outside of the meeting and discussing it with people. And obviously, you wouldn't want to post published articles, and you wouldn't want to present posters, for example, until you've got a patent application on file. A few months after you've filed the application, the UK office does a search, and this gives you kind of your first idea of whether the UK Patent Office thinks that it's patentable. So it can be useful because you've then got kind of some more information about how you might want to proceed with the application. 12 months after you've filed the first application is the deadline for filing other applications for the same invention. So this is kind of the world domination phase, if you like. And at this point, you could file further applications overseas or internationally, and they're able to claim the filing date of the original application. So this means that they effectively get knocked back a year in time, which means that any disclosure of the invention you've done over that year doesn't count against the patent application, which is obviously really useful because it means you can then go and publish articles or market a product and seek investments, for example. 6 months after that, or 18 months after you filed the first one, the application is then published. So I've got here an example of an international patent application publication. It's one of our applications. And at this point, provisional protection begins, certainly in the UK, if it's an application filed in English. And so the benefit of this is that if you do get a patent granted, anybody who kind of infringes your patent between the date of publication and the date of grant could be liable for damages. So you're kind of hopefully already getting some benefit from it. Then 2 years after filing is when examination typically begins. And so this is kind of an adversarial process with the UK IPO or whatever national patent office you're dealing with, where we'll represent you and aim to get the patent office to agree to grant a patent that kind of meets all your commercial goals and gives you the broadest protection possible. And so that in that way, it would hopefully generate the most value for your business. And then kind of the examination process can take, one plus years really. And so once that's sorted, 3 to 5 years after you filed it is usually when the patent will be granted. And so this can seem like a long time, but actually having patent pending isn't a bad thing generally, because it gives uncertainty to your competitors about what patent's going to be granted in the end. But then once it is granted, you can of course gain all the benefits of that patent. So once it's granted, you need to maintain the patent, and these are annual renewal fees, which increase every year. This is just to make sure that everybody who owns a patent really wants it, and it's actually commercially important for them. And so the patent office is just trying to make sure that if you don't really need the patent, then you don't pay the renewal fees anymore. You have 20 years since the date of filing while the patent's granted, and in that time, you can stop everybody else from using your patent. You can claim patent box tax relief in the UK, which means that kind of tax on profits from patented inventions is reduced. And also, of course, you could hopefully commercialize the invention and police any third parties who might be infringing. And so I'll just quickly touch on a few alternatives to patents, which are trade secrets and confidential technical information, which are fairly similar. A trade secret is effectively any business information that allows an organization to have a competitive edge. But there's a few extra requirements, and that must be that you are actively trying to keep the information secret, and it has commercial value because other people don't know about it. So one of the most common trade secrets would be kind of recipes, because them in themselves might not be patentable, but the other thing with a recipe is that people are often doing it behind closed doors and then bringing out maybe a chocolate bar or something from that recipe. So it's hard to actually tell if they're even doing the patented process if you did patent that recipe. So yeah, trade secrets are useful where it's some kind of information which you just don't want to share with people effectively, because with a patent application, you have to describe it fully. And so anything you put in there will become part of public knowledge. And after the 20 years, anyone can do it. So that's where kind of trade secrets and confidential information can be very useful. And that's my half over. So I'll stop sharing now and hand over to Neil.
I think that's okay. Yeah, thanks, Henry. So as Henry mentioned in his introduction, I'm just going to run through a couple of examples, some real world case studies, I guess, of the type of things that can be protected in the advanced materials field. So what can be protected? You can protect products and compositions. So that may, for example, be an alloy composition to a particular steel alloy. Could be a polymer composition, ceramic composition. It could also be a product which is formed from that composition. All of those things are protectable. As Henry touched on before as well, you can also protect pieces of equipment apparatus. So, for example, if an apparatus was modified in some way and that led to an improvement in efficiency, then that could be patentable. Or similarly, if that modification also enabled you to produce a product which had an improved set of properties, then again, you could potentially obtain protection for that modified and improved piece of apparatus. Processes, you can, in addition to being able to protect compositions and products, you can also protect how these are made. So as an example, if you subject a composition to a particular heating regime, a particular heat treatment, and that heat treatment enables you to obtain a product having, again, an improved set of properties, then that improved process is potentially patentable. And finally, I'm just going to touch on some specific uses. So this is when there is a known composition, a known compound, and it's applied in a new way. That's also possible to obtain a patent for those kind of things too. So I'm just going to start off with discussing nickel-based alloys as an example of a composition that can be protected. So nickel-based alloys generally have very good temperature resistance and oxidation resistance, but they are susceptible to cracking. And one of the known solutions to minimize that negative effect of cracking was to control the zirconium content in those particular alloys and to keep those as low as possible. Now, the inventors for the application I'm going to discuss, they were in the business of additive manufacturing, and they actually discovered that you could reduce cracking in these nickel-based alloys and also improve other properties, even when the zirconium content was above 0.06 weight%. in the alloy. Why is that not moving? Oh, sorry. And what they did was they filed an application directed to this particular claim, so a nickel-based alloy for additive manufacturing comprising in weight percent a certain amount of carbon, a certain amount of titanium, and a certain amount of zirconium. So in particular, a zirconium content above 0.06 weight percent. Now, when it came to examining the application, the examiner identified one relevant prior art document, and in particular, they cited a particular powder mixture, and this is powder mixture F. So as you can see from this mixture, it contains all of the key elements that we're currently claiming here. So it contains carbon, titanium, and also zirconium. And importantly, this powder mixture contains 0.1% carbon, which falls within this claimed range. It also contains 4% titanium, falling within this claimed range, and a value of 0.2 weight percent zirconium, which again falls within the claimed range of more than 0.06 weight percent. So based on this powder mixture, a novelty objection was raised, meaning that the application, this claim couldn't be granted. So what do you do in those situations? You have to look to some of your dependent claims and some of the other subject matter that you include in your application when filing. So if this is your main claim and you receive such a novelty objection, these dependent claims essentially act as fallback positions to help you overcome the objection and distinguish your invention from the prior art. So in this particular example, there were a number of dependent claims directed to different elements in specified quantities. And all of these elements on their own independently potentially represented a way for overcoming the novelty objection. So from a brief comparison of these elements and their quantities with this powder mixture F here, you can see that powder mixture F doesn't contain any tantalum and it doesn't contain any niobium. And so the incorporation of either of these elements in these quantities into this main claim represents one way for overcoming the novelty objection. And similarly, these elements, aluminium, tungsten, chromium, and cobalt, although they're present in this powder mixture F, the values here that are disclosed are outside of these claimed ranges. And so they each represent, again, a viable option for overcoming the novelty objection. So when deciding what to limit to, which would be the best amendment, a business typically considers, okay, well, what is my commercially available, what is my commercial product that I'm selling, and what limitation would best protect that? So in this present case, the applicants decided to make an amendment by introducing tungsten in the amount of 1.8 to 2.6 weight percent. This not only distinguished the claimed invention, so it essentially restored the novelty of the claimed invention, because as you can see here, powder mixture F contains 8% tungsten, which is outside of this claimed range. It also enabled the applicant to successfully argue the presence of an inventive step. And that basically means that's essentially an obviousness test. And the argument went along the lines of this powder mixture F, it does contain tungsten, but this value here of 8% is so much higher than the value here, the upper limit of this claimed range of 2.6 weight percent, that a skilled person would not realistically consider modifying this amount to a value which would fall within this claimed range. And that argument was accepted, and it was possible to obtain a granted patent on this basis. So that's compositions. Moving on to apparatus claims, and in particular an additive manufacturing tool. Just to give you a bit of background on this invention, initially the inventors found that the stiffness, wear resistance, and high temperature properties of a titanium alloy could be could be improved if it was bonded with a ceramic material. So I think in the example they gave, it was a titanium alloy bonded with a titanium diboride compound. And as I said, that improved a number of properties. They filed an application to cover this concept broadly. So as you can see from this claim here, they didn't mention titanium or titanium diboride specifically, because then that would afford them quite a limited scope of protection, but they've tried to cover that quite broadly. So as you can see from this claim and from this schematic here, you can see that the claim is directed to a powder for use in additive manufacturing. It comprises a first particulate component with a first mean diameter. So that's essentially the metal particle, or the titanium or titanium alloy here. It also includes a second particulate component with a second mean diameter. So this is the ceramic material here. And there's also a requirement as to the size of these two particles. So as you can see, it says wherein the first mean particle diameter is at least twice the second mean particle diameter, which can be seen here, shown schematically. And it also requires that the particles of the second component are bonded to the particles of the first component. So unfortunately for the applicant, this claim was considered to lack novelty, and they sought to remedy this by filing an amendment, again looking at one of their dependent claims to see how they could distinguish from the prior art. And they filed an amendment to further clarify that the powder comprises a binder material. Unfortunately for the applicant in this case, the novelty objection was maintained because the examiner noted that in addition to the prior art disclosing a steel alloy and a ceramic material bonded to it, it also disclosed a polymeric adhesive, which in practice could be used to bond that ceramic component to that steel alloy. So unfortunately, this claim, which is directed to the powder, lacked novelty and couldn't be granted. All was not lost, however, because the application also included a claim to an additive manufacturing tool. So this tool, in broad terms, contained the first powder holder here. So this is represented by holder 11, a second powder holder here, represented by this box 15, and more specifically holders 12 and 13, a blender 30, which is operable to blend powders dispensed from the first powder holder and the second powder holder. So in practice, this is virgin powder and recycled powder, which has been generated after an additive manufacturing process. And it also includes a dispenser for dispensing the powder once it's been blended in the blender. Now, the prior art document cited against this invention was different from that cited against D1, but the prior art document here did disclose an additive manufacturing tool, which had at least two powder holders, a blender, and a dispenser for dispensing the blended powder. Again, to overcome this objection, the applicant made an amendment, and they included the limitation that the blender comprises a binder dispenser for adding the binder material to the powder, and also a dryer for drying the powder to form the feedstock. Now, this modification, this amendment, doesn't seem to be particularly groundbreaking, but it was still possible for the applicant to obtain a granted patent based on this claim, because there was a specific teaching in the prior art which said it's undesirable during blending for the virgin powder to bind to the recycled powder. So there was a clear teaching away that this was undesirable because that would lead to an inhomogeneous mixture, which is not great for additive manufacturing. So based on this teaching away and based on this information, the applicant then made the argument, well, if it's a bad thing that the virgin powder and the recycled powder bond together, then the skilled person, the person skilled in the art, is never going to provide this piece of kit with a binder dispenser for dispensing a binder, so that those materials would bind together. And that was enough to convince the examiner to grant a patent. Basically, it was considered to be novel and inventive, and a patent granted on the back of that. So what I'm trying to get at here is that the amendment that you make, it doesn't have to be groundbreaking, especially if there's something in the application in the application that you file that says that there's some kind of technical benefit associated with that, and also if there's something in the prior art which is cited against your application, which would teach away from that proposed solution, that can be utilized in your favor to try and get a patent granted. So the next thing I'm going to touch on now is processes, and I'm going to specifically talk about a graphene production and functionalization method. So in this example, the invention relates to a method for producing a pre-treatment coating, and this method comprises 4 steps. In step 1, graphite ore is mined from a graphite ore body. This graphite ore is then subjected to an electrolytic treatment to expand the graphitic material to make it easier to exfoliate in a subsequent step, no doubt. The next step is to subject that expanded graphitic material to an exfoliation treatment to obtain single layer graphene and few layer graphene, and then to functionalize that graphene which is obtained with a coupling agent. So then the graphene can be adhered to a metal substrate in use once it's coated. So when it came to examination, in this example, 2 documents were cited. Document D1 that disclosed a method for electrochemically exfoliating graphite into graphene, but it didn't disclose the step of functionalizing the graphene with a coupling agent. So on that basis, because it didn't disclose this step 4, this claim was considered to be novel over document D1. A second document was also cited, and document D2 didn't disclose the steps of subjecting the graphite ore to an electrolytic treatment, but it did disclose an exfoliation treatment to obtain single layer graphene and few layer graphene, and it also disclosed the steps of functionalizing graphene with a coupling agent. So again, because D2 didn't disclose these first 2 steps, this claim was considered to be novel over D2. So just to recap, the claim is novel over D1 and it's novel over D2 because these documents independently do not disclose all of the features of this claimed invention. So while the claim was considered to be novel, there was unfortunately an objection raised indicating that the claim lacked an inventive step. Essentially, the examiner argued that the teachings in D1 directed to the electrolytic treatment would then be combined with the teachings of D2, which disclosed the steps of exfoliating graphene and then subsequently functionalizing that graphene with a coupling agent. So again, the applicant had to have a think about what to do, how to get around these objections, and in particular this inventive step objection. And what they did was, in this case, they decided to put a bit more meat on the bone. They amended the claim by putting a bit more meat on the bone on what was actually involved in the exfoliation treatment. So as you can see here from the amendment that was made in bold, they clarified that the exfoliation treatment was a combined chemical and high pressure treatment, which involved the steps of intercalating the graphitic material with an intercalating agent and a surfactant, and then subjecting the intercalated graphitic material to a high pressure homogenization treatment. Now, neither of these documents, D1 or D2, disclosed this specific exfoliation treatment, and they also didn't provide any pointers towards this treatment either. I think in D2, the exfoliation treatment involved ultrasonication, for example. So there's clearly a point of difference here, and now the question is, well, what is the benefit of this amendment of this particular exfoliation treatment? And what the inventors found, and what was successfully argued, was that this exfoliation treatment, compared to the exfoliation treatment in the prior art, was much more gentler, which enabled the size of the graphene flakes that were obtained to be bigger, to be maintained, so they weren't broken down into smaller particles. And this had a significant effect in the barrier resistance that was obtained in the coatings that were subsequently deposited onto metal substrates. So again, to get around this, just to kind of recap, to get around these objections, it was novel because the prior art didn't disclose all of the features in a single document of the claimed invention, and we had to essentially further specify some of the process steps, and because those additional process steps had associated with them some kind of technical benefit that resulted in an improvement, it was possible to overcome the objections here, and a patent eventually granted. So just going on to the final example, this relates to a specific use, and in particular, it's directed to a golf ball in this instance. So as you can see here from this example and this claim, the invention relates to a golf ball consisting of an inner part comprising an elastomeric polymer and at least a reinforcing agent, an outer part comprising a coating layer provided with dimples, which is what you normally see on a conventional golf ball. And it also requires that graphene nanoplatelets are dispersed within the reinforcing agent in said inner part of the golf ball. And these graphene nanoplatelets have certain requirements. So as you can see here, the graphene nanoplatelets are quite specific in that they have to have a specific lateral size. They also have to have a specific thickness, and they also have to have a certain carbon to oxygen ratio. So during examination of this claim, two documents were cited again. This first document, D2, interestingly enough, was owned by the same applicant for this golf ball invention, and it disclosed a process for preparing pristine graphene. And the graphene obtained from that process was the graphene that's being claimed here. So the graphene obtained had the same lateral size, it had the same thickness, and it also had the same carbon to oxygen ratio. But because D2 didn't say anything about how this graphene would be utilized, and certainly didn't allude to its inclusion in a golf ball, and in particular its inclusion in an inner part of a golf ball, this claim was considered to be novel over this document D2. A second document was also cited, document D5, and although this document did disclose golf balls and the inclusion of a graphitic material in that golf ball, the graphitic material that was included was exfoliated graphite, and that graphite had a thickness that was no less than 400 nanometers. So if you compare that to the thickness of the graphene nanoplatelets that are incorporated into this golf ball, you can see that the graphene nanoplatelets in D5 are much, much bigger, and approximately 10 times bigger than the graphene nanoplatelets disclosed here. So again, on this basis, and the difference in size between the exfoliated graphite and the thickness of the graphene nanoplatelets here, it was considered that this claim was novel over D5. So again, we've got a novel claim, but unsurprisingly, the examiner raised an inventive step argument against this claim, saying that it was something obvious that a skilled person would consider. And the argument essentially went along the lines that it would be obvious to substitute this exfoliated graphite with a thickness of no less than 400 nanometers with the disclosed and known graphene that was obtained from the method disclosed in D2, essentially the claimed graphene here. Now, the benefit of this claim and the technical effect of incorporating the claimed graphene was that when the ball was struck, there was a softer impact, and it also enabled the ball to travel further. There was also improvements in wear resistance over time. Now, neither of these prior art documents alluded to those technical benefits of this particular that were associated with this particular claim. And so there was one possible argument there that this claimed invention was inventive on that basis. And there was also the additional argument that in D5 there was an explicit teaching away. Again, just refer here. It says that the exfoliated graphite should be no less than 400 nanometers thick. So with this in mind, and with the skilled person faced with the problem of providing a golf ball which has a softer impact and improved wear resistance and the ability to travel further when struck, the skilled person, it was argued, would not obviously substitute this exfoliated graphite with these graphene nanoplatelets here, because these are much smaller, and you have this teaching away here that the graphite material should not be less than 400 nanometers. So with that in mind, yeah, it was possible to overcome the inventive step objection that was raised and a patent granted in due course. And I just want to briefly mention as well that this specific example relates to a golf ball, but there are other applications filed by this applicant where this particular graphene these particular graphene nanoplatelets have been incorporated into different materials. So I think there's other applications where they've been incorporated into tires and into clothing as well. And each of those applications have been granted or are on the way to being granted as well. So just to wrap up then. It's possible to protect a variety of inventions in the advanced materials field. These can be in the form of products and compositions. It's possible to protect different pieces of apparatus and pieces of equipment. Possible to protect processes and also new uses of known compositions. As hopefully I've demonstrated there, in order to get a patent granted, the claimed invention must be novel and it must also be inventive, in that there must be at least one difference between what you're trying to protect, and that claimed invention should also be non-obvious in light of what is disclosed in the prior art documents that have been cited against your application. So as you can see, there's many things to consider, and many things where, lots of thought needs to be given about how to craft a patent application when it's first being drafted, so that you have those necessary fallback positions that you can potentially rely on as you move through the patent application process. So if you do have a germ of an idea, or you have an invention that you think that is patentable and you want to protect, it's always best to speak to a patent attorney who will be able to advise initially on whether the invention could be patentable, and also how best to go and protect that invention as well.